Welcome to Unwritten Law. This is John Vecchione here with Mark Chenoweth, and it's a little bit of a return call.
Deja vu.
Deja vu. We have filed a brief before the First Circuit in Relentless v. Commerce, which many of our listeners will be familiar with. That was a companion case in Loper Bright. They got rid of Chevron deference. And Loper Bright is stayed, and there has been no circuit court decision there. And we got a district court decision. And the district court, I think I've mentioned before.
Yeah, from the District of Rhode Island.
Granted summary judgment against our clients, relying on the overturned, vacated decision of the First Circuit the last time. So we have appealed. We don't think that's the proper way to go on this. Now, as you all recall, I think this is the case whereby under the Magnuson-Stevens Act, the agencies, NOAA and Commerce and National Marine Fishery, say that they can put at-sea monitors, which are a
at-sea monitor, as our client says.
Exactly, at-sea monitor. And on their ships, on their boats, and have the fishermen pay for them up to $710 a day. And this despite the fact that the statute says there are observers, and the observers have always been understood for 30 years to be government-paid folks who make sure that you're catching the right size fish, and the bycatch, which is the fish you throw back, is all being done properly. They don't do anything at all for the fishermen or the work of the boat at all. And so the agencies have made up this paid-for monitor, paid for by the regulated party. And what the district court said was, well, I go and look what the First Circuit did the last time before they were overturned, and they say that, Congress kind of knew this was going to happen, and it does say that they get to put these observers on the boats, which no one disputes. That's what the statute says. But it says they have to carry the observers. And he has used this statute to say, well, that means they can charge for them. The other thing he's used is something that's only appeared in these cases. In the fish cases that I had when I was at cause of action, Gaethel, in a concurring opinion by Judge Kayada, said there's a default norm. And this default norm is that the regulated party pays for the regulation, the administrative costs. And that concurring opinion in this Gaethel opinion cited nothing. What it said is that hundreds of regulations follow this pattern, so it's a default norm. But, as we say in this brief, Mark, that's just following agency practice. That's not making your own judgment as a court about it. It's actually a monstrous Loper Bright violation where at least those guys were looking at one agency with supposedly some idea about what this regulation was and deferring to it. He's deferring to all the agencies about whether the courts have a default norm.
Well, and you'd hope for better judicial logic than everybody's doing it.
Yeah.
But even here, everybody's not doing it. It's not true that across the broad range of inspection regimes, for example, that the regulated party has to pay the costs of the salaries of the inspector.
That's the second jump, because even though there are cases, and I will have to admit this, that yes, if they tell you have to have a net that's so big so that fish go through it, the fish you're not allowed to catch go through it, well, you have to pay for that net. But then again, you own that net. You can sell it to the next guy, right? These observers, you don't own them. They have a duty to the government, not to you.
They don't work for you.
They don't work for you.
Yeah.
So but you pay their contract, by gum. So,
and the statute does say you have to provide them a berth on the boat. You have to feed them if you're out at sea for some.
Those are the administrative costs Congress acknowledged that you would have to pay, and everyone knew it. It's written down. Everyone read it at the time. And I will say this: we have found no record of any fisherman or company or anyone opposing that.
Back in 1990 or whatever.
No one's opposed it that we know of. But as soon as they said you got to pay probably more than you're paying the fisherman on your boat per day, the $710, well, of course everyone complained. But they had no idea this could happen when the amendment came through. So our clients never got to talk to their congressman about it or anything. And
Well, that's the way it works when something's not in the text of the regulation. You
Right.
assume that it's not part of what's covered by it.
correct. And so we've put in a brief and we've gone through that this isn't how you do statutory construction
Anymore.
anymore. But there's not only no deference to the agencies, but you have to look at the statute. And the statute for foreign fishermen allows, we make this clear, apples to apples. It says that if this fund that's created by foreign fishermen runs out, the foreign fishermen have to contract with the observers. Doesn't say anything like that for domestic folks.
Right.
And then there's other sections up in the northern Pacific, that's Alaska, and in these fisheries where they know who all the fishermen are and they divide the fish equally. It's called laps, or if not equally, by a percentage. They too can split up the cost of these observers, but it's in the statute. You can read it. You know whether it's happening or not.
And none of those three things apply to the Atlantic herring fishery. First of all, the North Atlantic is not the North Pacific.
Correct.
I think we can all agree on that.
That's true.
Domestic vessels are not foreign vessels.
Right.
And these aren't laps.
Right.
So those are the only times when Congress has said that you can charge the vessel for the cost of the observer.
That's right. And so we think we have a very good case here, but this default norm, which is only found, by the way, in cases I have been involved in. So only in Gaethel, only in...
We call it the Vecchione curse.
Yes, and only in Relentless. And I go through it, and since Gaethel, the concurring opinion in Gaethel appeared in 2017, no court has cited it except the Relentless courts. And I will say this, John Roberts, God love him, when they didn't take this question the first time, but he did say when he was talking about the procedural background of Relentless, he didn't call it the default norm. He called it a default norm.
Default norm in scare quotes, too.
In scare quotes as well. So I don't think they like it. I don't think they were going, hey, yeah, that's right. So I'm hoping the First Circuit will not double down.
They should take a hint.
They should take a hint. I mean, I don't want to be – and one of the problems here is we were all deciding what to call the district court Loper Bright and Relentless cases because the appellate cases are Relentless Roman numeral 1, Loper Bright Roman numeral 1. I said, well, what do we call them? I said, well, we've got to call up the Little Sisters of the Poor's lawyers and find out what they're doing because they must have like 3-4 district court cases,
That's right.
right?
They've done this song and dance a few times.
Right. So in any event, we are going back up to the First Circuit, and I think we're going to have some amicus support. And I hope that the demise of Chevron by our clients who brought that about, it would be thin gruel if this were to stand after they've gone through everything to get rid of this Chevron deference. And remember what that means, what the original opinions mean. It meant that it was ambiguous and unclear, but they just went with the agency's view of it. Well, if it's ambiguous and unclear and you're charging people for something, that's a congressional thing to do. Congress makes the rules about who pays what. Who pays what is pretty much like the main function of Congress.
Well, not only that, but one of the things you say in this brief that really I found compelling, John, is that, look, when they all looked at this before, with one exception we can get to,
right.
They said that the only way we could sort of get to the idea that the regulation allows this or that the statute allows this is by deferring to the agency under Chevron. Well, now that option is off the table, the decision they reach ought to be clear. Now you can't do it because you can't defer under Chevron anymore. And before you said that was the only way you can get there.
That's right.
So the fact that the district court here, notwithstanding the fact that Chevron deference is off the table now, still found a way to decide that the statute allows them to charge the vessels is perplexing to me.
Well, I think the district court looked at, he knows there's only 6 guys on the first, 6 judges. They're not all guys, but they're all on the First Circuit. And I think he didn't even give us oral argument. I think he looked at it and said, are they going to do anything different? I'm wondering.
I hope they will. I think they will.
I hope they will.
There's
well.
some good judges on the First Circuit.
No question.
I don't always agree with Judge Lynch, but she's
right.
a sharp cookie. I mean,
yeah,
I think
correct.
she's.
So I think it's pretty compelling. But so we'll see what happens. But we do have this. We're back up there again. The government, and the other thing is that I find interesting is that the government stayed Loper Bright so that they don't get a decision out of the D.C. Circuit so they can negotiate some sort of settlement. But they're not staying this one. I don't know if it's because they got a district court opinion or they don't care about the First Circuit, or it's because the name is not the first name in the case.
Oh, well, that might be it. But I think it's because they won at the district court level, and so it makes them timid about settling or something. But you have other good arguments in this brief, John. You talk about the penalty provision of the MSA, Magnuson-Stevens Act, not providing the power to assign industry-funded at-sea monitors.
Right. That's the other thing. So they say that because there's a penalty provision that says that if you don't pay a contracted observer when you're required to, that means that Congress thought you could have contracted observers all the time. But there's a couple of things going on there. First, in some things in the statute have the government contracts with the observer, and you pay the government. So it could be in that. And in others, outside the Magnuson-Stevens Act, the Mammal Protection Act, the Endangered Species Act, they have observers who you have to contract with.
Right. This penalty provision doesn't just apply to the Atlantic herring fishery. This is a broad provision.
So what Congress was putting in there, from our view, is that whenever some other part of our statutes say that you have to contract with an observer, we can penalize you for not paying those guys, right? But it doesn't mean that we say in all areas you can have these paid-for contractors.
Right.
So, and it's very odd that a penalty provision would provide the power, right?
For sure.
So they may be saying, well, this is evidence of it, but it's not evidence of that because it's equally, or I think more strongly, evidence that they knew there were observers out there who were going to be contracted with, like in foreign fisheries. Then you got to pay them, and you can be penalized if you don't. Makes perfect sense. And I think this time, I will say in this brief, I think I most clearly laid out how the statute works.
How it hangs together.
How it all hangs together.
Yeah.
How each brick of it makes sense. All right, here these guys have to pay and contract with observers. In this other area, we shift the cost of the observers in a different manner. And then if you don't follow those, you can be penalized. That doesn't mean that they said now you can have these observers. The other thing that has never been explained, and I think we hit it hard here, is why when Congress has allowed observers in the domestic and to be paid for by industry in one way or another,
like in the North Pacific,
right? They've always capped it.
Right.
They cap it. Here, it's 20%. It's 5 times.
Well, and I was going to say the cap is like 2 or 3% or something like that.
Yeah, 2, 3, 5% of catch, I think, in the North Pacific. But the fact is, it's way less than 20%. Way less.
Yeah, Congress would never authorize this.
And so, yeah, and I think that the cost-benefit balance that Congress put in is the cost-benefit that the agencies have to follow, even if you buy the idea that they're allowed to put these ASMs wherever they want. That the cost of the ASMs has to be what Congress has said is reasonable, even if you thought that was correct. It can't just be anything.
Well, plus, if they can put this cost on the industry, then that cuts Congress out of the equation of deciding the amount of monitoring that they want.
Well, that's it. They can fund themselves through the regulated party. They don't need Congress. They become a machine that goes by itself. And what we put in here is, look, air marshals have to be on the various planes.
I like
right?
that analogy. Yeah.
And it is our cause of action folk. Ryan Mulvey came up with that some time ago, and I like that. But also now we have ICE, right? So everyone sees ICE in the news. Well, if they capture you, do you have to pay their salary? Right? There's no.
That's like the old Soviet days when they would shoot you and then send the
bullet.
Cost of the bullet to your family.
Yes, exactly.
Yeah.
So all these regulatory people, the meat packers, I mean, the meat inspection's been around for over 100 years under the Food and Drug Act and things, and no one has said without congressional authorization that is chargeable to industry. And that one, you could at least you could see Congress saying, let's do this. And if they did it, that would be okay. I mean, it would at least be legal. It would be constitutional. But if they don't do it, Congress is not giving these agencies the power to just fund themselves. And the way you can see this is all the fights over the CFPB, right? Congress was very clear they wanted it to be funded without going back to Congress because they didn't want Congress interfering. I mean, that was the whole point of it, right? It was this big – but there was a huge fight over it. Congress fights every time they put in something where funds are going to be directed to an agency without having to go back to Congress. They talk about it, right? They have a big fight about it. You see it in the legislative history. You see it in the colloquies and everything. Here, as we said, nobody complained in 1990 because I don't think that they were giving away the funding power to the agency.
Well, and you also point out that the legislative history doesn't doesn't support that idea.
There's not anything like it. So I really think there are very good arguments here, and I hopefully will win in the First Circuit, and that'll be the end of it. But if it's not,
well, at least you'll get oral argument in the First Circuit, I predict, and you can give them an earful.
Yes, I think that. Well, the other thing is, it always reminds me, and we put this in the brief, that it's 250th anniversary of the Declaration of Independence, and one of the things there is they're creating new officers to eat out our substance, right?
Right.
And this is a new office. The observers were an unpaid government position, and the ASMs are a industry paid position. That's different, and in the regulation they have slightly different things that they do as well. But the fact is, it's a big difference between if the government's going to pay for the person checking up on you and you're going to pay for it. That's big. So you're right there in Boston Harbor where the First Circuit sits. And
Boston Harbor.
Yeah, Boston Harbor, and the fish and the fishing boats are still there. There's still some, not as many as there used to be, but there's still some. So I'm just hoping that that'll be the end of it. Well, you've been listening to Unwritten Law, and we hope to see you next time.
As we like to say here at NCLA, let judges judge, let legislators legislate, and stop bureaucrats from doing either.